Your Excellencies, Your Majesties, honorable members of the universe, both fauna and flora, in the presence of everyone assembled under my voice, and in full view or realization of the high calling I assume as President of the Republic of South Africa, I, Sylvester Volane Madala Mangolele, swear or solemnly affirm that I will be faithful to the Republic of South Africa and will obey, observe, uphold, and maintain the Constitution and all other laws of the Republic. And I solemnly and sincerely promise that I will always promote all that will advance the Republic and oppose all that may harm it, protect and promote the rights of all South Africans, discharge my duties with all my strength and talent to the best of my knowledge and ability and true to the dictates of my conscience, do justice to all, and devote myself to the well-being of the Republic and all of its people. And so help me God. As we, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi sikelela i-Afrika, morena boloka setjhaba sa heso. God sien South Africa. God bless South Africa. Mudzimu fuchusetsa Afrika, hosi katekisa Afrika. The Republic of South Africa is one sovereign democratic state founded on the following values: human dignity, the achievement of equality and the advancement of human rights and freedoms, non-racialism and non-sexism, supremacy of the Constitution and the rule of law, universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. There is a common South African citizenship. All citizens are equally entitled to the rights, privileges, and benefits of citizenship, and equally subject to the duties, and responsibilities of citizenship. National legislation must provide for the acquisition, loss, and restoration of citizenship. The national anthem of the Republic is determined by the President by proclamation. The national flag of the Republic is black, gold, green, white, red, and blue, as described and sketched in Schedule 1 of the Constitution of the Republic of South Africa, Act 108 of 1996. The official languages of the Republic are Sepedi, Sesotho, Setswana, Siswati, Tshivenda, Xitsonga, Afrikaans, English, isiNdebele, isiXhosa, and isiZulu. Recognizing the historically diminished use and status of the indigenous languages of our people, the state must take practical and positive measures to elevate the status and advance the use of these languages. The national government and provincial government may use any particular official language for the purpose of government, taking into account usage, practicality, expense, regional circumstances, and the balance of the needs and preference of the population as a whole or in the province concerned. But the national government and each provincial government must use at least 2 official languages. Municipalities must take into account the language use and preference of their residents. The national government and provincial governments, by legislative and other measures, must regulate and monitor the use of official languages without detracting from the provisions of subsection 2 in the Constitution of section 6. All official languages must enjoy parity of esteem and must be treated equitably. A pan-South African language board established by national legislation must promote and create conditions for the development and use of all official languages. The Khoi, Nama, San languages, and signed languages, and promote and ensure respect for all languages commonly used by communities in South Africa, including German, Greek, Gujarati, Hindu, Portuguese, Tamil, Telugu, and Urdu, and Arabic, Hebrew, Sanskrit, and other languages used for religious purposes in South Africa. The Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. The rights in the Bill of Rights are subject to the limitations contained or referred to in Section 36 of the Constitution or elsewhere in the bill. We will get to the provisions of Section 36 at the later stage. The Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. A provision of the Bill of Rights binds a natural or juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. When applying a provision of the Bill of Rights to a natural or juristic person, as I have said, any court, or where appropriate, another independent and impartial tribunal or forum, in order to give effect to a right in the bill, must apply, or if necessary develop, the common law to the extent that legislation does not give effect to that right, and may develop rules of the common law to limit the right, provided that the limitation is in accordance with section 36(1), which we will discuss at a later stage. A juristic person is entitled to the rights in the Bill of Rights to the extent required by the nature of the rights and the nature of that juristic person. Everyone is equal before the law and has the right to equal protection and benefit of the law. Equality includes the full and equal enjoyment of all rights and freedoms. To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. The state may not unfairly discriminate or directly or indirectly against anyone on one or more grounds, including race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. No person may unfairly discriminate directly or indirectly against anyone or on one or more grounds in terms of what I have said. National legislation must be enacted to prevent or prohibit unfair discrimination. Discrimination on one or more grounds listed in what I have already alluded to is unfair unless it is established that the discrimination is fair. Everyone has inherent dignity and the right to have their dignity respected and promoted. Everyone has a right to life. Everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause, not to be detained without trial, not to be free from all forms of violence from either public or private sources, not to be tortured in any way, and not to be treated or punished in a cruel, inhumane, or degrading way. Everyone has the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction, to security in and control over their body, and not to be subjected to medical or scientific experiments without their informed consent. No one may be subjected to slavery, servitude, or forced labor. Everyone has the right to privacy, which includes the right not to have their privacy or home searched, their property searched, their property seized, or the privacy of their communication infringed. Everyone has the right to freedom of conscience, religion, thought, belief, and opinion. Religious observance may be conducted at state or state-aided institution, provided that those observances follow rules made by the appropriate public authorities. They are conducted on an equitable basis, and attendance at them is free and voluntary. This section does not prevent legislation recognizing marriages concluded under any tradition or a system of religious, personal, or family law, or system of personal and family law under any tradition or adherence to by person professing a particular religion. Recognition in terms of what I have said just now must be consistent with the section and the other provisions of the Constitution. Everyone has the right to freedom of expression, which includes freedom of the press and other media. Everyone has the right to freedom of expression, which includes freedom to receive or impart information or ideas. Everyone has the right to freedom of expression, which includes freedom of artistic creativity and academic freedom and freedom of scientific research. The right in subsection 1 does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitute incitement to cause harm. Everybody has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petitions. Everyone has the right to freedom of association. Every citizen is free to make political choices, which includes the right to form a political party. Every citizen is free to make political choices, which includes the right to participate in the activities of or recruit members for a political party. And every citizen is free to make political choices, which includes the right to campaign for a political party or cause. Every citizen has a right to free, fair, and regular elections for any legislative body established in terms of the Constitution. Every adult citizen has the right to vote in elections for any legislative body established in terms of the Constitution, and to do so in secret, and to stand for public office, and, if elected, to hold office. No citizens may be deprived of citizenship. Everyone has the right to freedom of movement. Everyone has the right to leave the Republic. Every citizen has the right to enter, to remain in, and to reside anywhere in the Republic. Every citizen has the right to a passport. Every citizen has the right to choose their trade, occupation, or profession freely. The practice of a trade, occupation, or profession may be regulated by law. Everyone has the right to fair labor practices. Every worker has the right to form and join a trade union, to participate in the activities and programs of a trade union, and to strike. Every employer has the right to form and join an employer's organization and to participate in the activities and programs of any employer's organization. Every trade union and every employer's organization has the right to determine its own administration, programs, and activities. Every trade union and every employer's organization has the right to organize and to form and join a federation. Every trade union, employer's organization, and employer has the right to engage in collective bargaining. National legislation may be enacted to regulate collective bargaining. To the extent that the legislation may limit a right in this chapter, which is the Bill of Rights, the limitation must comply with Section 36(1), which we will come to pass in addressing. National legislation may recognize union security arrangements contained in collective agreements. To the extent that the legislation may limit a right in this chapter or the Bill of Rights, the limitation must comply with Section 36(1) to be discussed. Everyone has the right to an environment that is not harmful to their health or well-being, and everyone has the right to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, promote conservation and secure ecologically sustainable development and use of natural resources while promoting justifiable and economic and social development. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. And I will repeat that again. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. Property may be expropriated only in terms of law of general application, for a public purpose or in the public interest, and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court, or where appropriate, another independent and impartial tribunal or forum such as the National Assembly, the Defence Force Service Commission, the National Council of Provinces, and so forth, and all other spheres of government. The amount of the compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard to all relevant circumstances, including the current use of the property, the history of the acquisition and use of the property, the market value of the property, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvement of the property, and the purpose of the expropriation. For the purpose of this section, the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access of all South Africa's natural resources, and property is not limited to land. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. A person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled to the extent provided by an Act of Parliament either to tenure which is legally secure or to comparable redress. A person or community dispossessed of property after 19 June 1913 as a result of past racially discriminatory laws or practices is entitled to the extent provided by an Act of Parliament, either to restitution of that property or to equitable redress. No provision of this section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure from the provisions of this section is in accordance with the provisions of section 36(1). Parliament must enact the legislation referred to in what I have said. Everyone has the right to have access to adequate housing. The state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. No one may be evicted from their home or have their home demolished without an order of court made after considering all relevant circumstances. No legislation may permit arbitrary evictions. Everyone has the right to have access to health care services, including reproductive health care. Everyone has the right to have access to sufficient food and water. And everyone has the right to have access to social security, including, if they are unable to support themselves and their dependents, appropriate social assistance. The state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of each of these rights. No one may be refused emergency medical treatment. Every child has the right to a name and a nationality from birth. Every child has the right to family care or parental care, or to appropriate alternative care when removed from family environment. Every child has the right to basic nutrition, shelter, basic health care services, and social services. Every child has the right to be protected from maltreatment, neglect, abuse, or degradation. Every child has the right to be protected from exploitative labor practices. Every child has the right not to be required or permitted to perform work or provide service that are inappropriate for a person of that child's age, or place at risk the child's well-being, education, physical or mental health, or spiritual, moral, or social development. Every child has the right not to be detained except as a measure of last resort, in which case, in addition to the rights of a child enjoys under Section 12 and 35, the child may be detained only for the shortest appropriate period of time, and has the right to be kept separately from detained persons over the age of 18 years and treated in a manner and kept in conditions that take account of the child's age. To have a legal practitioner assigned to the child by the state and at state expense in civil proceedings affecting the child if substantial injustice would otherwise result, and not to be used directly in armed conflict, and to be protected in terms of armed conflict. A child's best interests are of paramount importance in every matter concerning the child. In Section 28 of the Constitution, a child means a person under the age of 18 years. Everyone has the right to basic education, including adult basic education, and everyone has the right to further education which the state, through reasonable measures, must make progressively available and accessible. Everyone has the right to receive education in the official language or languages of their choice in public educational institution where that education is reasonably practicable. In order to ensure the effective access to and implementation of this right, the state must consider all reasonable educational alternatives, including single medium institution, taking into account equity, practicability, and the need to redress the results of past racially discriminatory laws and practices. Everyone has the right to establish and maintain at their own expense independent educational institutions that do not discriminate on the basis of race, are registered with the state, and maintain standards that are not inferior to standards at comparable public education institutions. Subsection 29(3) of the Constitution does not preclude state subsidies for independent educational institutions. Everyone has the right to use the language and to participate in the cultural life of their choice, but no one exercising these rights may do so in a manner inconsistent with any provision in the Bill of Rights. Persons belonging to a cultural, religious, or linguistic community may not be denied the right with other members of that community to enjoy their culture, practice their religion, and use their language, and to form, join, and maintain cultural, religious, and linguistic associations and other organs of civil society. The rights that I have just mentioned may not be exercised in a manner inconsistent with any provision of the Bill of Rights. Everyone has the right of access to any information held by the state, and any information that is held by the state and everyone has the right to access to any information that is held by another person and that is required for the exercise or protection of any rights. National legislation must be enacted to give effect to this right and may provide for reasonable measures to alleviate the administrative and financial burden on the state. Everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. Everyone whose rights have been adversely affected by administrative action has the right to be given written reasons. National legislation must be enacted to give effect to these rights and must provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. Impose a duty on the state to give effect to the rights in subsection 1 and 2 and promote an efficient administration as obligated in terms of section 33 of the Constitution. Access to court is defined as that everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. Everyone who is arrested for allegedly committing an offense has the right to remain silent, to be informed promptly of the right to remain silent and of the consequences of not remaining silent. Everyone who is arrested for allegedly committing an offense has the right not to be compelled to make any confession or admission that could be used in evidence against that person, to be brought before a court as soon as reasonable possible, but not later than 48 hours after the arrest, or the end of the first court day after expiry of the 48 hours. If the 48 hours expires outside ordinary court hours or on a day which is not an ordinary court day, at the first court appearance after being arrested, to be charged or to be informed of the reasons for the detention to continue or to be released, and everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interest of justice permit, subject to reasonable conditions. Everyone who is detained, including every sentenced prisoner, has the right to be informed promptly of the reasons for being detained. Everyone who is detained, including sentenced prisoners, has the right to choose and to consult with a legal practitioner and to be informed of this right promptly. Everyone who is detained, including every sentenced prisoner, has the right to have a legal practitioner assigned to the detained person by the state and at state expense, if substantial injustice would otherwise result, and to be informed of this right promptly. Everyone who is detained, including every sentenced prisoner, has the right to challenge the lawfulness of the detention in person before a court, and if the detention is unlawful, to be released. Everyone who is detained, including every sentenced prisoner, has the right to conditions of detentions that are consistent with human dignity, including at least exercise and the provisions at state expense of adequate accommodation, nutrition, reading material, and medical treatment. And everyone who is detained, including every sentenced prisoner, has the right to communicate with and be visited by that person's spouse or partner, next of kin, chosen religious counselor, and chosen medical practitioner. Every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. Every accused person has a right to a fair trial, which includes the right to have adequate time and facilities to prepare a defense. Every accused person has a right to a fair trial, which includes the right to a public trial before an ordinary court. Every accused person has a right to a fair trial, which includes the right to have their trial begin and conclude without unreasonable delay. Every accused person has a right to a fair trial, which includes the right to be present when being tried. Every accused person has a right to a fair trial, which includes the right to choose and be represented by a legal practitioner and to be informed of this right promptly. Every accused person has a right to a fair trial, which includes the right to have a legal practitioner assigned to the accused person by the state and at state expense, if substantial injustice would otherwise result, and to be informed of this right promptly. Every accused person has a right to a fair trial, which includes the right to be presumed innocent, to remain silent, and not to testify during the proceedings. Every accused person has the right to a fair trial, which includes the right to adduce and challenge evidence. Every accused person has a right to a fair trial, which includes the right not to be compelled to give self-incriminating evidence. Every accused person has a right to a fair trial, which includes the right to be tried in a language that the accused person understands, or, if that is not practicable, to have the proceedings interpreted in that language. Every accused person has a right to a fair trial, which includes the right not to be convicted for an act or omission that was not an offense under either national or international law at the time it was committed or omitted. Every accused person has a right to a fair trial, which includes the right not to be tried for an offense in respect of an act or omission for which that person has previously been either acquitted or convicted. Every accused person has a right to a fair trial, which includes the right to the benefit of the least severe of the prescribed punishment if the prescribed punishment for the offense has been changed between the time that the offense was committed and the time of sentencing. And every accused person has a right to a fair trial, which includes the right of appeal or review by a higher court. Whenever what I have said requires information to be given to a person, that information must be given in a language that the person understands. Evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. And what I have been alluding to all along in relation to the limitation of rights, as explicitly set forth in terms of Section 36, which provides that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable, justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and less restrictive means to achieve the purpose. Except as provided as provided in what I have said, or in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. A state of emergency may be declared only in terms of an Act of Parliament, and only when the life of the nation is threatened by war, invasion, general insurrection, disorder, natural disaster, or other public emergencies, and the declaration is necessary to restore peace and order. A declaration of a state of emergency and any legislation enacted or other action taken in consequence of that declaration may be effective only prospectively and for no more than 21 days from the date of the declaration, unless the National Assembly resolves to extend the declaration. The Assembly may extend a declaration of state of emergency for no more than 3 months at a time. The first extension of the state of emergency must be by a resolution adopted with the supporting vote of the majority of the members of the National Assembly. Any subsequent extension must be by a resolution adopted with a supporting vote of at least 60% of the members of the National Assembly. A resolution in terms of what I've said may be adopted only following a public debate in the Assembly. Any competent court may decide on the validity of a declaration of a state of emergency, any extension of a declaration of a state emergency, or any legislation enacted or other action taken in consequence of a declaration of a state of emergency. Any legislation enacted in consequence of a declaration of a state emergency may derogate from the Bill of Rights only to the extent that the derogation is strictly required by the emergency, and the legislation is consistent with the Republic's obligation under international law applicable to states of emergencies, conforms to subsection 5, and is published in the National Government Gazette as soon as reasonably possible after being enacted. And subsection 5, what I've just alluded to about in terms of the confirmation, is that no act of parliament that authorizes a declaration of a state of emergency, and no legislation enacted or other action taken in consequences of a declaration may permit or authorize indemnifying the state with any person in respect of any unlawful act, any derogation from this section, or any derogation from a section mentioned in column 1 of the table of non-derogable rights, a section here, if it's section 9, 10, or whatever, that is what table 1 of column non-derogable rights means, to the extent indicated opposite that section in column 3 of the table. And when you look at the table, you find the reality that all that is being placed in this particular table is non-derogable rights, in which section 9, equality with respect to unfair discrimination solely on the grounds of race, color, ethnicity, or social origin, sex, religion, or language. Section 10, human dignity, is extent to which it is the right is protected is entirely. Section 11, which is life, the extent to which the right is protected is that it's entirely. You cannot find an excuse not to protect what is entirely protected. Freedom and security of the person with respect to subsection 1D and E and 2C. Slavery, servitude, and forced labor with respect to slavery and servitude, meaning that you can be forced into labor in the state of emergency. And then slavery or children with respect to section 1, subsection 1D and E, the rights in paragraphs 1 and 2 of subsection 1G and subsection 1 in respect of children of 15 years and younger. Arrested and detained person in the state of war will have a right with respect to subsection 1B and C and 2D, the rights of in paragraph A to 0, subsection 3, excluding paragraph 4, subsection 4, subsection 5, with respect to the exclusion of evidence if the admission of that evidence would render the trial unfair. Whenever everyone is detained without trial in consequence of a derogation of rights resulting from a declaration of state of emergency, the following conditions must be observed. An adult family member of a friend or of the detainee must be contacted as soon as reasonably possible and informed that the person has been detained. A notice must be published in the National Government Gazette within 5 days if that person being detained, stating the detainee's name and place of detention and referred to the emergency measure in terms of which that person has been detained. The detainee must be allowed to choose and be visited at any reasonable time by a medical practitioner. The detainee must be allowed to choose and be visited at any reasonable time by a legal representative. A court must review the detention as soon as reasonably possible, but no later than 10 days after the date person was detained, and the court must release the detainee unless it is necessary to continue the detention to restore peace and order. A detainee who is not released in terms of a review under paragraph E, or who is not released in terms of a review under this paragraph, may apply to a court for a further review of the detention at any time after 10 days have passed since the previous review, and the court must release the detainee unless it is still necessary to continue the detention to restore peace and order. The detainee must be allowed to appear in person before any court considering the detention, to be represented by a legal practitioner at those hearing, and to make representations against continued detention. The state must present written reasons to the court to justify continued detention if the detainee and must give a copy of those reasons to the detainee at least 2 days before the court reviews the detention. If a court releases a detainee, that person may not be detained again on the same grounds unless the state first show good cause for re-detaining that person. And this, what I have said, does not apply to persons who are not South African citizens and who are detained in consequence of international armed conflict. Instead, the state must comply with the standards binding on the Republic under international humanitarian law in respect of the detention of such persons. And to further state, anyone who listed in section 38 of the Constitution has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. The person who may approach a court are anyone acting in their own interest, anyone acting on behalf of another person who cannot act in their own name, anyone acting as a member of or in the interest of a group or class of persons, anyone acting in the public interest, and an association acting in the interest of its members. When interpreting the Bill of Rights, a court, tribunal, or forum must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. When interpreting the Bill of Rights, a court, tribunal, or forum must consider international law. And when interpreting the Bill of Rights, a court, tribunal, or forum may consider foreign law. When interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. The Bill of Rights does not deny the existence of any other right or freedoms that are recognized or conferred by common law, customary law, or legislation, to the extent that they are consistent with the bill. And in relation to cooperative governance, in the Republic of South Africa, government is constituted as national, provincial, and local spheres of government which are distinctive and interdependent and interrelated. All spheres of government must observe and adhere to the principles in Chapter 3 of the Constitution and must conduct their activities within the parameters of that chapter. That all spheres of government and all organs of state within each sphere must preserve the peace, national unity, and the indivisibility of the Republic. I will repeat again. That is why you see this peace on your screen. Principles of cooperative governance and intergovernmental relations is that all spheres of government and all organs of state within each sphere must preserve the peace, national unity, and the indivisibility of the Republic. All spheres of government and all organs of state within each sphere must secure the well-being of the people of the Republic. All spheres of government and all organs of state within each sphere must provide effective, transparent, accountable, and coherent government for the Republic as a whole. All spheres of government and all organs of state within each sphere must be loyal to the Constitution, the Republic and its people. All spheres of government and all organs of state within each sphere must respect the constitutional status, institutions, powers, and functions of government in the other spheres. All spheres of government and all organs of state within each sphere must not assume any power or function except those conferred on them in terms of the Constitution. All spheres of government and all organs of state within each sphere must exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of government in another sphere. And all spheres of government and organs of state within each sphere must cooperate with one another in mutual trust and good faith by fostering friendly relations, assisting and supporting one another, informing one another of, and consulting one another on matters of common interest. Cooperate with one another in mutual trust and good faith by coordinating their actions and legislation with one another. Cooperate with one another in a mutual trust and good faith by adhering to agreed procedures, and cooperating with one another in mutual trust and good faith by avoiding legal proceedings against one another. An Act of Parliament must establish or provide for structures and institutions to promote and facilitate intergovernmental relations, and provide for appropriate mechanisms and procedures to facilitate settlement of intergovernmental disputes. An organ of state involved in an intergovernmental dispute must make every reasonable effort to settle the dispute by means of mechanisms and procedures provided for that purpose, and must exhaust all other remedies before it approaches a court to resolve the dispute. If a court is not satisfied that the requirements of subsection 3 have been met, it may refer a dispute back to the organ of state involved. In relation to composition of Parliament, Parliament consists of the National Assembly, and Parliament consists of the National Council of Provinces. The National Assembly and the National Council of Provinces participate in the legislative process in a manner set out in the Constitution. The National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the President, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. The National Council of Provinces represents the provinces to ensure that provincial interests are taken into account in the national sphere of government. It does this mainly by participating in the national legislative process and by providing a national forum for public consideration of issues affecting the province. President may summon Parliament to an extraordinary sitting at any time to conduct special business. The seat of Parliament is at Cape Town, but an Act of Parliament enacted in accordance with Section 76(1) and 5 of the Constitution may determine that the seat of Parliament is elsewhere. In the Republic, the legislative authority of the national sphere of government is vested in Parliament, as set out in Section 44. In the Republic, the legislative authority of the provincial sphere of government is vested in the provincial legislature, as set out in Section 104 of the Constitution. And in the Republic, the legislative authority of the local sphere of government is vested in the Municipal Council, as set out in Section 156 of the Constitution. The national legislative authority is vested in Parliament, confers on the National Assembly the power to amend the Constitution. The national legislative authority is vested in Parliament, confers on the National Assembly the power to pass legislation with regard to any matter, including a matter within a functional area listed in Schedule 4, but excluding, subject to subsection 2, a matter within a functional area listed in Schedule 5. And the national legislative authority as vested in Parliament confers on the National Assembly the power to assign any of its legislative powers, except the power to amend the Constitution, to any legislative body in another sphere of government. And the national legislative authority as vested in Parliament confers on the National Council of Provinces the power to participate in amending the Constitution in accordance with Section 74 of the Constitution, the National Legislative Authority as vested in Parliament confers on the National Council of Provinces the power to pass, in accordance with Section 76, legislation with regard to any matter within a functional area listed in Schedule 4 and any other matter required by the Constitution to be passed in accordance with Section 76. And the National Legislative Authority as vested in Parliament confers on the National Council of Provinces the power to consider, in accordance with Section 75, any legislation passed by the National Assembly. Parliament may intervene by passing legislation in accordance with Section 76(1) with regard to a matter falling within a functional area listed in Schedule 5 when it is necessary to maintain national security, when it is necessary to maintain economic unity, when it is necessary to maintain essential national standards, when it is necessary to establish minimum standards required for the rendering of services, or when it is necessary to prevent unreasonable action taken by a province which is prejudicial to the interest of another province or to the country as a whole. Legislation with regard to a matter that is reasonably necessary for or incidental to the effective exercise of a power concerning any matter listed in Schedule 4 is, for all purposes, legislation with regard to a matter listed in Schedule 4. When exercising its legislative authority, Parliament is bound only by the Constitution and must act in accordance with and within the limits of the Constitution. The National Assembly and the National Council of Provinces must establish a joint rules committee to make rules and orders concerning the joint business of the Assembly and Council, including rules and orders to determine procedures to facilitate the legislative process, including setting a time limit for completing any steps in the process, to establish joint committees composed of representatives from both the Assembly and the Council to consider and report on bills envisaged in Section 74 and 75 that are referred to such a committee, to establish a joint committee to review the Constitution at least annually, and to regulate the business of the Joint Rules Committee, the Mediation Committee, a Constitutional Review Committee, and any joint committee established in terms of paragraph B in Section 45(1) of the Constitution. Cabinet members, members of the National Assembly and delegates to the National Council of Provinces have the same privileges and immunities before a joint committee of the Assembly and the Council as they have before the Assembly or the Council. The National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members in terms of an electoral system that is prescribed by national legislation, is based on the National Common Voters Roll, provides for a minimum voting age of 18 years, and the National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members in terms of an electoral system that results in general in proportional representation. An Act of Parliament must provide a formula for determining the number of members of the National Assembly. Every citizen who is qualified to vote for the National Assembly is eligible to be a member of the National Assembly, except anyone who is appointed by or is in the service of the state and receives remuneration for that appointment or service other than the President, Deputy President, Ministers, and Deputy Ministers, and other office bearers whose functions are compatible with the functions of a member of the Assembly and have been declared compatible with those functions by national legislation. Every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly, except permanent delegates of the National Council of Provinces or members of a provincial legislature or municipal council. Every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly, except unrehabilitated insolvent. Every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly, except anyone declared to be of unsound mind by a court of the Republic. Or every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly, except anyone who, after this section took effect, is convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct consisting of the offense would have been an offense in the Republic, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. A disqualification under this paragraph ends 5 years after the sentence has been completed. A person who is not eligible to be a member of the National Assembly in terms of subsection 1A or B may be a candidate of the Assembly, subject to any limits or conditions established by national legislation. A person who loses membership of the National Assembly, a person loses membership of the National Assembly if that person ceases to be eligible, or a person loses membership of the National Assembly if that person is absent from the Assembly without permission in circumstances for which the rules and orders of the Assembly prescribe loss of membership. Or a person loses membership of the National Assembly if that person ceases to be a member of the party that nominated that person as a member of the Assembly. Vacancies in the National Assembly must be filled in terms of national legislation. Before members of the National Assembly begin to perform their functions in the Assembly, they must swear or affirm faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2 of the Constitution. National Assembly is elected for a term of 5 years. If the National Assembly is dissolved in terms of Section 50, or when its term expires, the President, by proclamation, must call and set dates for an election which must be held within 90 days of the date the Assembly was dissolved or its term expired. A proclamation calling and setting dates for an election may be issued before or after the expiry of the term of the National Assembly. If the result of an election of the National Assembly is not declared within the period established in terms of Section 190, or if an election is set aside by a court, the President, by proclamation, must call and set dates for another election, which must be held within 90 days of the expiry of that period or of the date which the election was set aside. The National Assembly remains competent to function from the time it is dissolved or its term expires until the day before the first day of polling for the next assembly. The President must dissolve the National Assembly if the Assembly has adopted a resolution to dissolve with supporting vote for a majority of its members, and the President must dissolve the National Assembly if the 3 years have passed since the Assembly was elected. The acting President must dissolve the National Assembly if there is a vacancy in the office of President and the acting President must dissolve the National Assembly if the Assembly fails to elect a new President within 30 days after the vacancy occurred. After an election, the first sitting of the National Assembly must take place at the time and or date determined by the Chief Justice, but not more than 14 days after the election result has been declared. The Assembly may determine the time and duration of its other sittings and its recess periods. The President may summon the National Assembly to an extraordinary sitting at any time to conduct special business. The sitting of the National Assembly are permitted at places other than the seat of Parliament only on the grounds of public interest, security or convenience, and if provided for in the rules and orders of the Assembly. At the first sitting after its election, or when necessary to fill a vacancy, the National Assembly must elect a Speaker and a Deputy Speaker from among its members. The Chief Justice must preside over the election of a Speaker or designate another judge to do so. The Speaker presides over the election of a Deputy Speaker. The procedure set out in Part A of Schedule 3 applies to the election of the Speaker and the Deputy Speaker. The National Assembly may remove the Speaker or Deputy Speaker from office by resolution. A majority of the members of the Assembly must be present when the resolution is adopted. In terms of its rules and orders, the National Assembly may elect from among its members other presiding officers to assist the Speaker and Deputy Speaker, except where the Constitution provides otherwise. A majority of the members of the National Assembly must be present before a vote may be taken on a bill or an amendment to a bill. At least 1/3 of the members must be present before a vote may be taken on any other question before the Assembly. And except where the Constitution provides otherwise, all questions before the Assembly are decided by a majority of the votes cast. The member of the National Assembly presiding at a meeting of the Assembly has no deliberative vote, but must cast the deciding vote when there is an equal number of votes on each side of a question, and may cast the deliberative vote when a question must be decided with a supporting vote of at least 2/3 of the members of the Assembly. The President and any member of the Cabinet or any Deputy Minister who is not a member of the National Assembly may, subject to the rules and orders of the Assembly, attend and speak in the Assembly, but may not vote. In exercising its legislative power, the National Assembly may consider, pass, amend, or reject any legislation before the Assembly. And in exercising its legislative power, the National Assembly may initiate or prepare legislation, accept money bills. The national legislation must provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it. And the National Assembly must provide for mechanisms to maintain oversight of the exercise of national executive authority, including the implementation of legislation, and the National Assembly must provide for mechanism to maintain oversight of any organ of state. The National Assembly or any of its committees may determine and control its internal arrangement, proceedings, and procedures. And the National Assembly may make rules and orders concerning its business with due regard to representatives and participatory democracy, accountability, transparency, and public involvement. This is as contemplated in Section 57(1) of the Constitution. And to reaffirm this, I have done this instinctively and deliberately, because these are the obligations imposed in terms of the Constitution, and these are the obligations that must be fulfilled. Evidence or information before the National Assembly may be brought in terms of Section 56, which provides that the National Assembly or any of its committees may summon any person to appear before it to give evidence on oath or affirmation, or to produce documents. The National Assembly or any of its committees may require any person or institution to report to it. The National Assembly or any of its committees may compel, in terms of national legislation or the rules and orders, any person or institution to comply with a summon or requirement in terms of paragraph A or B, as I have said. And the National Assembly or any of its committees may receive petitions, representations, or submissions from any interested persons or institutions. And when internally arranging the proceedings, after receiving these petitions, representations, or submissions from any interested persons or institutions, the National Assembly may determine and control its internal arrangements, proceedings, and procedures. And the National Assembly may make rules and orders concerning its business with due regard to representatives and participatory democracy, accountability, transparency, and public involvement. The rules and orders of the National Assembly must provide for the establishment, compositions, powers, functions, procedures, and duration of its committees. The participation in the proceedings of the Assembly and its committee of minority parties represented in the Assembly in a manner consistent with democracy. That is what the rules and orders of the National Assembly must provide for. And the rules and orders of the National Assembly must provide also for financial and administrative assistance to each party represented in the Assembly in proportion to its representation, to enable the party and its leader to perform their functions in the Assembly effectively. And the rules and orders of the National Assembly must provide for the recognition of the leader of the largest opposition party in the Assembly as the leader of the opposition. Cabinet members, deputy ministers, and members of the National Assembly have freedom of speech in the Assembly and its committees, subject to its rules and orders, and cabinet members, deputy ministers, and members of the National Assembly are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything that they have said in, produced before, or submitted to the Assembly or any of its committees. Or cabinet members, deputy ministers, and many members of the National Assembly are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything revealed as a result of anything that they have said in, produced before, or submitted to the Assembly or any of its committees. Other privileges and immunities of the National Assembly, cabinet members, and members of the Assembly may be prescribed by national legislation. Salaries, allowances, and benefits payable to members of the National Assembly are a direct charge against the National Revenue Fund. Public access to and involvement to the National Assembly is determined in terms of Section 59 of the Constitution, which provides that the National Assembly must facilitate involvement in the legislative and other processes of the Assembly and its committees. And the National Assembly must conduct its business in an open manner and hold its sittings and those of its committees in public, but reasonable measures may be taken to regulate public access, including access of media to the Assembly and its committees, and the National Assembly must conduct its business in an open manner and hold its sitting and those of its committees in public, but reasonable measures may be taken to provide for the searching of any person and, where appropriate, the refusal of entry to or the removal of any person. The National Assembly may not exclude the public. I repeat, the National Assembly may not exclude the public, including the media, from a sitting of a committee unless it is reasonable and justifiable to do so in an open and democratic society. The National Council of Provinces is composed of a single delegation from each province consisting of 10 delegates. The 10 delegates are 4 special delegates consisting of the Premier of the province or the Premier, or if the Premier is not available, any member of the provincial legislature designated by the Premier either generally or for any specific business before the National Council of Provinces. And the delegates are 4 special delegates consisting of 3 other special delegates, and the 10 delegates are 6 permanent delegates appointed in terms of section 61(2). The Premier of a province, or if the Premier is not available, a member of the province's delegation designated by the Premier heads the delegations. Parties represented in a provincial legislature are entitled to delegates in the province's delegation in accordance with the formula set out in Part B of Schedule 3. A provincial legislature must, within 30 days after the result of an election that legislature is declared, determine, in accordance with national legislation, how many of each party's delegates are to be permanent delegates and how many are to be special delegates. And a provincial legislature must, within 30 days after the result of an election of that legislature is declared, appoint the permanent delegates in accordance with the nominations of the parties. The national legislation envisaged in subsection 2A, in section 61, of the Constitution, must ensure that the participation of minority parties in both the permanent and special delegates components of the delegation in a manner consistent with democracy. The legislature, with the concurrence of the Premier and the leaders of the parties entitled to special delegates in the province's delegation, must designate special delegates as required from time to time from among the members of the legislature. A person nominated as delegate must be eligible to be a member of the provincial legislature. If a person who is a member of a provincial legislature is appointed as a permanent delegate, that person ceases to be a member of the legislature. Permanent delegates are appointed for a term that expires immediately before the first sitting of the provincial legislature after its next election. A person ceases to be a permanent delegate if that person ceases to be eligible to be a member of the provincial legislature for any reason other than being appointed as permanent delegate, becomes a member of cabinet, has lost the confidence of the provincial legislature and is recalled by the party that nominated that person, causes to be a member, ceases to be a permanent delegate if that person ceases to be a member of the party that nominated that person and is recalled by that party. Or a person ceases to be a permanent delegate if that person is absent from National Council of Provinces without permission in circumstances for which the rules and orders of the council prescribes loss of office as a permanent delegate. Vacancies amongst the permanent delegates must be filled in terms of national legislation. Before permanent delegates begin to perform their functions in the National Council of Provinces, they must swear or affirm faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2. The National Council of Provinces may determine the time and duration of its sitting and its recess period. The President may summon National Council of Provinces to an extraordinary sittings at any time to conduct special business. Sittings of the National Council of Provinces are permitted at places other than the seat of Parliament only on the grounds of public interest, security or convenience, and if provided for in the rules and orders of the Council. The National Council of Provinces must elect chairpersons and 2 deputy chairpersons from among delegates. The chairperson and 1 of the deputy chairpersons are elected from among the permanent delegates for 5 years unless their terms as delegates expire earlier. The deputy chairperson is elected for a term of 1 year and must be succeeded by a delegate from another province. So every province is represented in term. The Chief Justice must preside over the election of the chairperson or designate another judge to do so. The chairperson presides over the election of the deputy chairpersons. The procedure set out in Part A of Schedule 3 applies to the election of the chairperson and deputy chairpersons. The National Council of Provinces may remove the chairperson or deputy chairperson from office in terms of its rules and orders. The National Council of Provinces may elect from among the delegates another presiding officer to assist the chairperson and deputy chairpersons, except where the Constitution provides otherwise. Each province has 1 vote, which is cast on behalf of the province by the head of its delegation. And all questions before the National Council of Provinces are agreed. At least 5 provinces vote in favor of the question. They are agreed when at least 5 provinces vote in favor of the question. An Act of Parliament enacted in accordance with the procedure established by either subsection 1 or subsection 2 of section 76 must provide for a uniform procedure in terms of which provincial legislature confer authority on their delegations to cast votes on their behalf. A cabinet members and deputy ministers may attend and may speak in the National Council of Provinces, but may not vote. The National Council of Provinces may require cabinet members, a deputy minister, or an official in the national executive or provincial executive to attend a meeting of the council or a committee of the council. Participation by local government representatives. No more than 10 part-time representatives designated by organized local government in terms of section 163 to represent the different categories of municipalities may participate when necessary in the proceedings of the National Council of Provinces, but may not vote. In exercising its legislative power, the National Council of Provinces may consider, pass, amend, propose amendments to, or reject any legislation before the Council in accordance with this chapter. And in exercising its legislative power, the National Council of Provinces may initiate or prepare legislation falling within a functional area listed in Schedule 4 or other legislation referred to in Section 76.3, but may not initiate or prepare money bills. Evidence or information before National Council of Provinces. The National Council of Provinces or any of its committees may summon any person to appear before it or to give evidence on oath or affirmation or to produce documents. The National Council of Provinces or any of its committee may require any institution or person to report to it. The National Council of Provinces or any of its committee may compel in terms of national legislation or the rules and orders any person or institution to comply with a summons or requirement in terms of what I have just alluded to you now recently. The National Council of Provinces or any of its committees may receive petitions, representations or submissions from any interested persons or institutions. Internal arrangements and proceedings of National Council are in terms of Section 70 and their privileges in terms of Section 71 of the Constitution, where public access to involvement in National Council and national legislative processes are in terms of Section 73 of the Constitution. Bills amending the Constitution are in terms of Section 74 of the Constitution. Ordinary bills not affecting provinces. Ordinary bills affecting provinces. Money bills. Mediation committee. Assent to bills. Application by members of National Assembly to Constitutional Court. Publication of acts, safekeeping of acts of Parliament, is what constitute Chapter 4 of the Constitution. I am Chapter 5 of the Constitution, and the head of state and head of the National Executive. I uphold, defend and respect the Constitution as the supreme law of the Republic and promote the unity of the nation and that which will advance the Republic. I have powers and functions entrusted by the Constitution and legislation, including those necessary to perform the functions of head of state and head of the National Executive. I am responsible for assenting to and signing bills, referring a bill back to the National Assembly for reconsideration of the bill's constitutionality, referring a bill to the Constitutional Court for a decision on the bill's constitutionality. I'm also responsible for summoning the National Assembly, a National Council of Provinces, or Parliament to an extraordinary sitting to conduct special business. As President, I am responsible for making any appointments that the Constitution or legislation requires the President to make, other than as head of the National Executive. I am responsible for appointing commissions of inquiry, also responsible for calling a national referendum in terms of an act of parliament. I'm also responsible for receiving and recognizing foreign diplomatic and consular representatives. I'm responsible for appointing ambassadors, plenipotentiaries, and diplomatic and consular representatives. I am responsible for reprieving or pardoning offenders and remitting any fines, penalties, and forfeitures, and conferring honors. The executive authority of the Republic is vested in the President. I exercise the executive authority together with other members of the Cabinet by implementing national legislation except where the Constitution or an Act of Parliament provides otherwise. I exercise executive authority together with other members of the Cabinet by developing and implementing national policy. As President, I exercise the executive authority together with other members of the Cabinet by coordinating the functions of the state departments and administration, by preparing and initiating legislation, and I exercise the executive authority together with the other members of the Cabinet by performing any other executive functions provided for in the Constitution or in national legislation. The election of the President is at its first sitting after its election, and whenever necessary to fill a vacancy. The National Assembly must elect a woman or man from amongst its members to be the President. The Chief Justice must preside over the election of the President or designate another judge to do so. The procedure set out in Part A of Schedule 3 applies to the election of the President. I was not elected. I took over as President, and we must elect him President in accordance with the terms that I have advanced before you. It is the Constitution that I uphold. It is the rule of law that must remain supreme. Not persons, not individuals, not any other organization. An election to fill a vacancy in the office of the President must be held at a time and on a date determined by the Chief Justice, but not more than 30 days after the vacancy has occurred. When elected President, a person ceases to be a member of the National Assembly, and within 5 days must assume office by swearing or affirming faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2. The President's term of office begins in assuming office and ends upon a vacancy occurring or when the person next elected President assumes office. No person may hold office as President for more than 2 terms, but when a person is elected to fill a vacancy in the office of President, the period between that election and the next election of a President is not regarded as a term. No person may hold office as President for more than 2 terms. But when a person elected to fill a vacancy in the office of President, the period between that election and the next election is not regarded as a term. When you understand the Constitution. The National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the President from office only on the grounds of a serious violation of the Constitution or the law, serious misconduct, or inability to perform the functions of office. Anyone who has been removed from the office of President in terms of subsection 1A or B may not receive any benefits of that office and may not serve in any public office. The acting President, when the President is absent from the Republic or otherwise unable to fulfill the duties of President, or during a vacancy in the office of the President, an office bearer in the order below acts as President, the Deputy President, a minister designated by the President, a minister designated by another member of Cabinet, the Speaker until the National Assembly designate one of its members. An acting President has the responsibilities, powers, and functions of the President. Before assuming the responsibilities, powers, and function of the President, the acting President must swear or affirm faithfulness to the Republic and obedience to the Constitution in accordance with Schedule 2. A person who is acting President has sworn or affirmed faithfulness to the Republic need not repeat the swearing or affirming procedure for any subsequent term as acting President during the period when the person next elected President assumes office. Cabinet consists of the President as the head of the Cabinet, a Deputy President, and ministers. The President appoints the Deputy President and ministers, assigns their powers and functions, and may dismiss them. The President must elect the Deputy President from among the members of the National Assembly, may select any number of ministers from among the members of the Assembly, and may select no more than 2 ministers from outside the Assembly. The President must appoint a member of the Cabinet to be the leader of government business in the National Assembly. The Deputy President must assist the President in the execution of the functions of government. The Deputy President and ministers are responsible for the powers and functions of the executive assigned to them by the President. Members of the Cabinet are accountable collectively and individually to a Parliament for the exercise of their powers and the performance of their functions. Members of the Cabinet must act in accordance with the Constitution, and members of the Cabinet must provide Parliament with full and regular reports concerning matters under their control. The President may appoint deputy ministers or any number of deputy ministers from among the members of National Assembly, and no more than 2 deputy ministers from outside the Assembly to assist the members of the Cabinet, and may dismiss them. Deputy ministers appointed in terms of subsection 1B are accountable to Parliament for the exercise of their power and the performance of their functions. When an election of the National Assembly is held, the Cabinet, the Deputy President, ministers, and any deputy minister remain competent to function until the person elected President by the next Assembly assumes office. Before any deputy president, minister, and any deputy minister begin to perform their functions, they must swear or affirm faithfulness to the Republic and obedience to the Constitution, in accordance with Schedule 2. Members of Cabinet and deputy ministers must act in accordance with the code of ethics prescribed by national legislation. Members of Cabinet and deputy ministers may not undertake any other paid work, act in any way that is inconsistent with their office, or expose themselves to any situation involving the risk of conflict between their official responsibilities and private interests. Or members of the Cabinet and deputy ministers may not use their position or any information entrusted to them to enrich themselves or improperly benefit any other person. The President, by proclamation, may transfer to a member of Cabinet the administration of any legislation entrusted to another member, or any power or function entrusted by legislation to another member. The President may assign to a Cabinet member any power or function of another member who is absent from office or is unable to exercise that power or perform that function. A Cabinet member may assign any power or function that is to be exercised or performed in terms of an Act of Parliament to a member of Provincial Executive Council or to a Municipal Council. An assignment and must be in terms of an agreement between the relevant Cabinet member and the Executive Council member or Municipal Council. Must be consistent with the Act of Parliament in terms of which the relevant power of the function is exercised or performed, and take effect upon proclamation by the President. So when I say you are this person as the President of the Republic, that's what you are. National interventions in provincial administrative is in terms of Section 100, and executive decisions must be in writing. A decision by the President must be in writing if it is taken in terms of legislation or has legal consequence. A written decision by the President must be countersigned by another Cabinet member if that decision concerns the functions assigned to other Cabinet members. Proclamations, regulations, and other instruments of subordinate legislation must be accessible to the public. National legislation may specify the manner in which the extent to which instruments mentioned in subsection 3 of Section 101 of the Constitution must be tabled in Parliament and approved by Parliament. If the National Assembly, by a vote supported by a majority of its members, passes a motion of no confidence in the Cabinet excluding the President must reconstitute Cabinet. If the National Assembly, by a vote supported by a majority of its members, passes a motion of no confidence in the President, The President and other members of the Cabinet and deputy members must resign. Provinces are dealt with in terms of Chapter 6 of the Constitution. Local government is dealt with in terms of Chapter 7 of the Constitution. The judiciary is dealt with in terms of Chapter 8 of the Constitution. And Chapter 9 institutions, which are the Public Protector, the South African Human Rights Commission, Auditor General, are in terms of Chapter 9, and the National Prosecuting Authority of the Republic. Chapter 10 embodies the basic principles of public administration. Chapter 11 embodies the security of the Republic.
Incoming mail.
And Chapter 12 contemplates traditional leaders, while Chapter 13 deals with finances and Chapter 14 with general issues concerning the administration or international law, general provisions of international law, which includes international agreements, where the negotiating and signing of all international agreements is the responsibility of the national executive. And international agreements bind the Republic only after it has been approved by resolution in both the National Assembly and National Council of Provinces, unless it is an agreement referred to in subsection 3. An international agreement in subsection 3 is of a technical, administrative or executive nature, or an agreement which does not require either ratification or accession, entered into by the National Executive, binds the Republic without approval by National Assembly and the National Council of Provinces, but must be tabled in the Assembly and Council within a reasonable time. Any international agreement becomes law in the Republic when it is enacted into law by national legislation. But a self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. The Republic is bound by international agreements which were binding on the Republic when this Constitution took effect. Customary international law is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. When interpreting any legislation, every court, tribunal, or forum must prefer any reasonable interpretation of the legislation that is consistent with international law over any alternative interpretation. Other matters is charters of rights in order to deepen the culture of democracy established by the Constitution. Parliament may adopt Charter of Rights consistent with the provision of the Constitution, which is the Universal Declaration of Human Rights, and that has been successfully adopted. Self-determination, the rights of the South African people as a whole to self-determination, as manifested in this Constitution, does not preclude within the framework of this right, recognition of the nation of the right to self-determination of any community sharing a common cultural and language heritage within a territorial entity in the Republic or in any other way determined by national legislation. To enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislation on an equitable and proportional basis. All constitutional obligations must be performed diligently and without delay. An executive organ of state in any sphere of government may delegate any power or function that is to be exercised or performed in terms of legislation to any other executive organ of state, provided the delegation is consistent with the legislation in terms of which the power is exercised or the function is performed. Or an executive organ of state in any sphere of government may exercise any power or performing any functions for any other executive organ of state of an agency or delegation basis. And the definitions are covered in the Constitution unless the context indicates otherwise. National legislation includes subordinate legislation made in terms of an Act of Parliament and legislation that was in force when the Constitution took effect and that is administered by the national government. Organs of state means any department of state or administration in the national, provincial or local sphere of government, or any other functionary or institution exercising a power or performing a function in terms of the Constitution or a provincial constitution, or exercising a public power or performing a public function in terms of any legislation but does not include a court or judicial officer. Provincial legislation includes subordinate legislation made in terms of Provincial Act and legislation that was in force when the Constitution took effect and that is administered by provincial government. And inconsistencies between different texts. In the event of an inconsistency between different texts of the Constitution, the English text prevails. Schedule 6 applies to the transition of the new constitutional order established by this Constitution and any matter incidental to that transition. The laws mentioned in Schedule 7 are repealed subject to Section 243 and Schedule 6. This Act, which I have said to you, is called the Constitution of the Republic of South Africa, 1996, and comes into effect as soon as possible on a date set by myself by proclamation, which may not be a date later than today, 6 October 2021. I have set different dates before the date mentioned in respect of different provisions of the Constitution, unless the context otherwise indicates. A reference in a provision of the Constitution to a time when the Constitution took effect must be construed as a reference to the time when that provision took effect. If a different date is set for any particular provision of the Constitution in terms of what I have done before, any corresponding provision of the Constitution of the Republic of South Africa, 1993, Act 200 of 1993, mentioned in the proclamation, is repealed with effect from the same date. Sections 213, 214, 215, 216, 218, 226, 227, 228, 229 and 230 come into effect immediately, but does not preclude the enactment of, in terms of the Constitution, of legislation envisaged in any of these provisions before the date. Until that date, which is today, any corresponding and incidental provision of the Constitution of the Republic of South Africa Act of 1993 remain in force. The Constitution, Act 108 of 1996, is the supreme law of the Republic. The invalidity of such is in terms of Section 172 of the Constitution, which provides that when deciding a constitutional matter within its power, a court, tribunal, or forum must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency, and may make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity. And when deciding a constitutional matter within its power, a court, tribunal, or forum may make any order that is just and equitable, including an order suspending the declaration of invalidity for any period and on any condition to allow the competent authority to correct the defect. The Supreme Court of Appeal, the High Court of South Africa, or a court of similar status may make an order concerning the constitutional validity of an act of Parliament, a provincial act, or any conduct of the President. But an order of constitutional invalidity has no force unless is confirmed by the Constitutional Court. A court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief to a party, or may adjourn the proceedings pending a decision of the Constitutional Court on the validity of the act or conduct. National legislation must provide for the referral of an order or constitutional invalidity of the Constitutional Court. Any person or organ of state with a sufficient interest may appeal or apply directly to the Constitutional Court to confirm or vary an order of constitutional invalidity by a court in terms of this section. The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has inherent power to protect and regulate their own process, and to develop the common law, taking into account the interest of justice. Fellow South Africans, and all people in the world, justice is what drives any economy to success. Justice is what does right to all people affected. We would want to run away from justice and hide behind power,